Hello, I'm attorney Vince Davis. 2026 has brought a new era to California's criminal justice system, and it is vital that you understand these changes. The state is now balancing aggressive new penalties for theft and drugs with significant reforms in police accountability and sentencing equity. Perhaps the most profound shift comes from the full implementation of Proposition 36, which has fundamentally altered how low-level crimes are prosecuted. Shoplifting or petty theft for items worth $950 or less can now be charged as a felony if there are prior theft convictions. Crucially, prosecutors can now combine the value of multiple thefts committed on different dates to reach that felony threshold. This is a major change. For drug possession, we are seeing the rise of treatment-mandated felonies. Defendants with prior drug convictions face mandatory behavioral health services. Completion of treatment can lead to dismissed charges, but failure to comply can now result in up to 3 years in state prison. The stakes are very high. Early projections for 2026 suggest we may see a 35% increase in the state prison population as these enhanced sentences take effect. Moving to retail crime, the 2026 framework has made several temporary task forces permanent to combat organized theft rings more effectively. Senate Bill 905 has officially eliminated the loophole requiring proof that a vehicle was locked. Any forcible entry with intent is now a serious crime. Auto burglary is punishable by up to 3 years. This represents a significant hardening of the state's stance on property crimes in our communities. We're also seeing stricter regulations on online fencing. Marketplaces must now strictly verify high-volume third-party sellers to prevent the sale of stolen goods. At the same time, groundbreaking standards for police conduct have taken effect. The No Secret Police Act is one of the most significant. Senate Bill 627 prohibits officers from concealing their faces during operations. This is intended to ensure officer identification and public accountability. Officers must now visibly display their agency name and either their name or badge number during all public interactions. Transparency is now mandated by law. Assembly Bill 572 also protects the families of those injured by police, requiring agencies to inform families of a victim's condition before any interrogation. Crucially, families are now permitted to have a support person or an attorney present. This is a vital protection for civil rights in California. The law is even addressing technology. New 2026 regulations require agencies using AI for crime reports to explicitly disclose its use. A human officer's signature is still required to verify the report's accuracy. We are ensuring that technology does not replace human accountability. Let's discuss the expansion of judicial power to correct past sentencing inequities. This is where the Racial Justice Act for All comes in. As of 2026, individuals with any felony conviction can petition the court for relief if they can prove racial bias played a role in their case. This applies regardless of when the conviction occurred. It is a powerful tool for addressing systemic issues in our legal history. Assembly Bill 321 now allows judges to reduce wobbler crimes from felonies to misdemeanors at any point before trial, not just in early stages. Courts also have broader authority under AB 600 to recall and modify sentences without requiring the consent of the district attorney. Judges can now focus on factors like rehabilitation and the defendant's age at the time of the offense to ensure justice is truly served today. However, for vehicular manslaughter while intoxicated, the minimum probation period has been raised to a mandatory 3 to 5 years. We are also seeing more nuanced protections for minors. New standards generally limit juvenile probation terms to 12 months. The focus has shifted toward rapid rehabilitation rather than long-term court supervision, giving young people a better path forward. Victim rights are also expanding. AB 406 provides protected leave for employees who are victims of crimes to attend court proceedings. And a specific revival window has opened for adult survivors of sexual assault to file civil claims that were previously barred. The California legal landscape in 2026 is complex. It requires a balanced approach to ensure your rights are protected under these new rules. Many counties are reporting fiscal challenges in funding these mandates, leading to a gap between the law on paper and its practical application. This means your defense depends more than ever on local resources and staying informed about ongoing litigation regarding these new laws. With nearly 800 new laws passed recently, it is easy to feel overwhelmed by the shifting legal ground beneath your feet. Whether you are facing charges under Proposition 36 or seeking relief through the Racial Justice Act, you need expert guidance. Understanding these changes is the first step toward protecting your future and the future of your family in this new legal environment. We are here to monitor these changes and provide the defense strategy you need to navigate these new California standards. From retail theft crackdowns to sentencing equity, 2026 is a year of transformation for our courts and our law enforcement agencies. Do not leave your case to chance. The legal system is becoming more technical, and the penalties for certain offenses are increasing dramatically. You deserve an advocate who understands the nuances of the 2026 legislative package and knows how to use it in your favor. We are committed to standing with you through every challenge. Your rights are our priority every single day in the courtroom. Call us now at 888-888-6582. My team is ready to help you navigate these complex new laws. I'm Vince Davis, and we are all in this together. Thank you for watching and stay safe.